Good morning, everyone, and thank you so much for joining us. Women's Enterprise Center offering today's Mentor Advisory Forum. This is a popular subject. Our human resources experts are on the line today, and I'm going to be introducing them shortly. So let me start by telling you first a little bit about Women's Enterprise Center. Those of you, some of you are very, very familiar, and others, this may be your first Mentor Advisory Forum. So, we want you to know that Women's Enterprise Center is a not-for-profit organization, and we're devoted to helping BC women launch, lead, and scale their own businesses. We have a full range of services, including training, such as these sessions, mentor advisory forums, live training. We do webinars. We host events. Lots of activities throughout all of BC. As well as training, we provide business loans up to $150,000 to start a business or buy a business or grow a business. So we have a loans program. We have skills training. Sorry, I'm going to have to stop. Someone's got background noise that's interfering. If you could be sure to put your phone on mute. Thank you. And as well as the loans and training, we also have free business advising. You can connect with our client service team to ask your questions or get some help from one of our business advisors, as well as a mentoring program. And we have a number of different models of mentoring programs. Take a look on our website. If you haven't already applied for a mentor, this week is our application week as well for applying for a mentor, so very timely. And my name is Dawn McCooey. I'm a business advisor with Women's Enterprise Center. I've been with Women's Enterprise Center a long time now, formerly as skills development manager, now working as a business advisor. Prior to coming to Women's Enterprise Center, I ran my own consulting firm in Victoria for 18 years with 32 staff and 3 offices, very, very busy times. And so, bringing to the table for our clients at Women's Enterprise Center lots of business background. But more importantly, I want to thank our 2 expert panelists today. We have on the line Sophia Arishe. And Sophia is the principal of Upskill Consulting, a human resources consulting firm based in Langley, BC. Offering tailored human resources support, services, and solutions to the Fraser Valley and Greater Vancouver regions. With more than 13 years of senior-level HR experience, Sophia has an in-depth understanding of how to help companies bridge their HR strategy with their business strategy, always building a stronger focus on people practices to translate into better business results. She has worked in both provincially and federally regulated companies in a wide range of industries, including education, engineering, public practice, accounting, manufacturing, law, and telecommunications. Sophia partners with clients, including companies of all sizes and in a wide scope of industries to provide end-to-end HR support. Some of her HR services and expertise include training, performance management, employee engagement, change management, strategic planning, policy and handbook development, employee relations, job descriptions, and on-call HR advisory support. Welcome, Sophia.
Thank you so much.
Thank you. We can't do this without our volunteers who come on board to help us when we need experts. I would also like to introduce Shawnee Love. Shawnee owns a company called Love HR. She has been interested in leadership since her very first job. And then her commerce degree from University of British Columbia nurtured that interest and launched her into a 20-year human resources career. Over these 20 years, her interests crystallized into the mission of building better businesses through their people. Then in 2008, Shawnee founded Love HR and delivers creative and practical HR solutions and strategies and advice for leaders and managers on culture, skill development, and effective people management. Love HR has worked with more than 200 clients, including family businesses, startups, small and medium-sized businesses across almost every industry, manufacturing, construction, real estate, tourism, hospitality, technology, healthcare, education, retail. Shawnee consults, advises, delivers people and culture strategies and solutions. And beyond her BCom degree, Shawnee holds numerous certifications, including Certified Professional in Human Resources and a Certified Management Consultant. Shawnee Love resides in West Kelowna, BC, but works with clients across Canada due to her extensive understanding of Canadian rules and regulations for employers and employees. Welcome, Shawnee.
Thank you. It's exciting to be here.
Just delighted to have both of you today. This is, as you can tell, as we can tell, an important subject for small business. And, we've got an amazing group of women business owners on the line. And, ladies, you will have an opportunity to ask questions. We've reserved time at the end, so please do save your questions. And I'm going to just start off, we're going to take a look at kind of the main learning objectives. And one of them was to understand the difference between an employee and a contractor and why that matters to small business. So, Sophia, I'm going to invite you to lead off on that.
Sure. So first off, thank you so much for having me, and I'm really excited that we have over 130 participants today, so welcome everybody. This is a hot topic for sure, and I'd say, a lot of my clients have asked, listen, Sophia, is there a definitive test out there or kind of factor that'll be conclusive, that'll let me know how to classify individuals, whether they are an employee or a contractor? And as much as I'd like to say it's black and white, there's definitely some gray there. But it's incredibly important for employers to get it right because the ramifications of getting it wrong can be really significant. And so I can walk you through a case in just a little bit, but I thought perhaps we could start with a little bit of a definition of the difference between an employee and a contractor. So an employee is someone who works under an employer-employee type relationship where, they're dependent on an employer and they have certain entitlements under the Employment Standards Act or legislation per province or common law. Whereas an independent contractor is someone who is self-employed and someone who works in a business type relationship with clients to provide a service. And, the central issue, although there is no black and white test to determine if an individual is an employer or contractor, really the central issue is around control. And the Canada Revenue Agency, for all of you on the line, is a really good resource. They clearly lay out the difference between an employee or someone who's self-employed. And, they go over four main factors to look at when they try to assess whether or not someone is an employee versus a contractor. And so really, Dawn, I can go over the four different types of tests or factors that we can all look into.
Sure. If you'd like to do that, I think we've got a couple of minutes for this question. So, yes, Sophia, go ahead and just briefly outline the four factors.
Perfect. So the first one is around direction and control. So essentially this one is asking, who decides when and how the work is done. So really if an employer is controlling the actions of a worker, including the nature of the work, where they're working, supervising performance, disciplining, managing the work, then really that individual is more likely deemed an employee. So that's the first factor is direction and control. The second one is around ownership of tools, equipment, supplies. And so, the question here is who owns what and who is responsible for it. So really if the employer is providing those tools and replacing them, then the individual is most likely an employee. The third one is around chance of profit or risk of loss. So CRA here talks about, who stands to make a profit or suffer a loss as a result of the working relationship. And if the individual bears the ultimate responsibility of profit or risk of loss, then that person is most likely considered a contractor. And the fourth factor is around integration. So here they're looking at how integrated an individual is in the business and how important that individual is in the operations of the business.
Sophia, I'm just going to interrupt for 1 minute. I apologize.
No problem.
Participants, someone has not put their phone on mute and we're listening to your background conversations. Please put your phone on mute. You'll still be able to hear us, and you'll be able to hear the speakers, but we can't continue if we have that much background noise. Thank you kindly, Sophia. I apologize.
No problem.
Okay.
So that's the last one is integration. So really if the individual plays a vital role in the business and its profits and interactions with its clients, then really the individual is considered an employee. So, ultimately these are four main factors that you can look for is that direction and control, ownership of tools, equipment, supplies, profit and risk of loss, and integration are the four main ones.
Great. That's a terrific summary, and that gives our participants something to look at if you're looking at an employee or a contractor, and just even doing a quick self-test against those four factors as a starting point.
Absolutely.
Shawnee, I would like to invite you to, if there's something you'd like to add, or an example, something to add to that.
Yeah, for sure. Thank you. Really, I totally agree. And as Sophia said, the information that Revenue Canada puts out there is really valuable and really helpful, and it's pretty clear. The other thing I might build on is that they do give companies the opportunity to determine the intent of the relationship, and I think that's important because sometimes it's worthwhile. Sometimes it's worthwhile to hire a contractor.
It's not wet. It's not going to work. I asked you if wet. Oh, wipe it on the top, so you can wet.
I'm so sorry.
Okay.
Ladies, someone does not have their phone on mute. Could I please ask you again, put your phone on mute? We're not able to listen to the speakers. Yeah, if you could please put your phone on mute.
Yes, I did.
No, I can hear you talking. Okay, there we go.
Okay. So sorry. I was just going to say that, as Sophia indicated, the shades of gray in this exist because, in many circumstances, you may have the control being the individual you hire, but you might provide some tools because they're proprietary tools. And so one of the other pieces that Revenue Canada looks at is the intent of the arrangement. So, the intent of the arrangement, of course, still has to be legitimate because, as the saying goes, if it looks like a duck and it quacks like a duck, they might actually deem you a duck. But if the intent of your arrangement is truly to have a contractor and you document a business agreement as such, you can, in those circumstances, even if you have a person who you're providing the tools to as a company, you might still be meeting the test of self-employed individual or contractor if all of the other criteria, or let's say ducks, are in a row. And I will tell you, if I can just share an example from my practice. In my experience, I get employers calling probably the same as Sophia does, where they say, I want to hire a contractor. What do I need to know? And the first thing I start with is okay, so tell me, when you say contractor, what do you mean? Because in my experience, they're usually referring to one of three types of people or three types of workers. The first type is actually a temporary employee. So it's just an employee who has a specified end date in their contract, and they call that a contractor. And that's actually technically, it's a misnomer. It's not the correct usage of the term. It's actually a temporary employee. And really, if they're going to write an offer letter, they should probably write an offer letter for an employee that has an end date on it. The second type is actually a true contractor. So it's someone, like Sophia or me even, that you'd have a business agreement with and a proposal and deadlines and due dates and we'd invoice you and those kinds of basic things. So that's a true contractor in that sense. And as Sophia already went through, some of the tests that you would understand to make them a contractor. The third is actually kind of some weird hybrid version of that, and it comes about either because the potential worker says, "Hey, I'd really like the tax benefits of being a contractor. Can you put me on as a self-employed individual, and I'll go forward accordingly." Or it goes and happens, and I've had this happen a couple times in my career where an employer's coming to me and saying, "Damn, source deductions are way too high, and I'm just going to let go of all my employees and I'm going to turn them into contractors." And truth be told, Revenue Canada's got that one figured out. So that's not a contractor. That's an employee. And you can't really get away with those source deduction avoidance just by pretending that somebody is not an employee, truth be told. So that's why they put that test out there for good information. And really I think our role as consultants is to say, hey, which one of these are you really trying to hire? And then, of course, when we understand which one, helping guide you through the process so that you can correctly document it and protect your business.
Absolutely. And, that really, I think both of you have really explained not only what Revenue Canada looks for, but just those understanding that difference between, how much control, are they a temporary employee, some measurements that can help a small business owner to begin to make that determination. But especially why it matters, because, the penalties it can be extremely expensive if someone's been working for years as a contractor and then they're deemed to be an employee. So, yeah, absolutely. Thank you both for kind of touching on those important pieces.
Dawn, can I give a quick example that happened not too long ago? I had
Please
a client who they weren't a client until they made this call to me, but they'd had somebody, as you described, who had worked as a contractor for a long time. And when Revenue Canada did an audit on that contractor and found that they hadn't been contributing their source deductions, and that contractor or supposed contractor didn't have the money, they claimed that they were actually an employee. Because they didn't have the money to pay up. And so the employer got embroiled in this audit by virtue of that situation and in the end did have to pay the source deductions for the person who had worked for them as a quote-unquote contractor but was actually an employee. So it does happen. It doesn't happen every day, but it happens.
Yes. Yeah. So it's an important piece in managing people.
It is, and I think, what we have to understand and the importance of it is that the employer really does take 100% of the risk. So, I've had clients before saying, listen, I had this great employee, but they do want to switch over to a contractor and we'd love to accommodate. And, my first reaction is we have to remember that you're going to take 100% of the risk. So they have to meet the factors of a contractor to be then switched over to a contractor. And, otherwise the risk of getting it wrong is that as an employer, you would have to back pay potentially income tax, EI, CPP, common law rights and obligations will come into play as well. So potentially paying somebody severance and notice. Employment Standards Act minimums may have to be back paid as well, including vacation pay and overtime and stat holidays. And so it just kind of goes on and on with potentially having to back pay somebody if you incorrectly categorize a relationship.
It's not something you want to be guessing at.
No. And, there was a case recently It was between two individuals suing it was a kitchen cabinetry company. And it's really interesting because I think that this sheds light on the importance of getting it right. These two individuals were hired by the employer in the early 1980s, and towards like 1987, it looks like here, the company switched them over to independent contractors. But really, their role didn't change. They were still on a schedule, still using the employer's tools and so forth, and so their working relationship and duties remained unchanged. And then work slowed down for this company, and so in 2007, they ended the contract with these two individuals and did not give them any severance pay because, according to them, they viewed these two as independent contractors. And what ended up happening was the ruling was that the company had to pay both of these individuals reasonable notice on termination because they were deemed employees. And the company was on the hook for damages of $125,000 in lieu of 26 months of notice. So that's huge. I mean, of course, these two individuals started in the 1980s, and so that's why the notice period was extensive. But it just shows that you've got to look at that relationship and categorize it properly.
Mm-hmm. Well, it certainly outlines the importance.
Mm-hmm.
I want to touch base now on one of the other pieces that we wanted to be sure people came away with. What are some of the key pieces of employment contracts? Now, I think both of you have mentioned employment contracts, having a contract, and in including that as part of your intent. So what makes up? Shawnee, we'll start with you, and then Sophia, I'll ask you to add in as well. But starting with Shawnee, the key pieces of an employment contract.
Okay. Well, I guess first I like to frame the term contract carefully because most employers don't have any kind of employment agreement in writing with their employees, at least as I understand it. But truth be told, not every employer, and if there's any lawyers on the line, please forgive me, this has been my experience. Truthfully, not every employer needs an employment contract with, 11 pages of legalese written by a lawyer. I always say to my clients, and it's just to sort of for effect an example, but I always say if you need this to stand up in court, so for example, you have intellectual property or you have serious confidentiality concerns, then certainly by all means go and speak with an employment lawyer. By the way, an employment lawyer, not just a business lawyer, because there are subtle nuances in the law that they don't teach in university necessarily and are learned on the job. So go for those good employment lawyers. But go to an employment lawyer and get them to write you up the document that you need. But for most employees, we really just want to set really good expectations about the job and the benefits and the perks and the conditions of employment. And so, my little sort of thing I say is look, if you need it to stand up in front of a judge, then you have to go and get an employment lawyer to write it up. And do not risk downloading it off the web because I see those contracts a lot and they're usually not worth the paper they're written on. And saying that, if you're one of the majority of employers that really just want to have clear expectations set up front, then an offer letter can be a really productive approach to documenting those. And I say that because, most employees, obviously if we're not hiring CEO level, we're hiring the average layperson like myself and like ourselves. If that being the case, most of employees just want plain English that sort of sets realistic expectations so that they can start their job and know when the various terms and conditions take effect. And so specific clauses that I like to put in my contracts or my offer letters.
I might have to stop again, Shawnee. Ladies, if you have not put your phone on mute, please put your phone on mute. We can hear your background conversation. We can hear your background conversation. Please put your phone on mute if you are a participant. Thank you.
Yeah,
Thanks again, Shawnee.
Yeah, no problem. So when I was just going to talk about the specific things I usually like to put in my offer letters. So, first and foremost, what's the name of the position? What's the start date? If there is an end date because you're hiring a temporary employee, then put the end date in as well. What's the rate of pay or salary? How do you pay them? As in, do they get paid semi-monthly or biweekly? What's the vacation accrual? I can't tell you how many times I've had, a disgruntled employee, come across my desk, and when I sit down with them, I find out that it's because the employer, somebody in the interview process, led them to believe that they might get more vacation or more money than they actually get paid on that first paycheck. Or sometimes they don't pay attention to the first paycheck, and it's the third or the fourth before they realize. So, that's really for me is about, just making sure that the person joining your organization knows what they're getting into. And as I said, the big terms, vacation, benefits, when do benefits kick in, what's your compensation, start end date if applicable, an overview of the job, and then some of the other important clauses that I put in, whether they're layperson documents or whether they're going through a legal lawyer, would also be clarification on what happens if we end the relationship. So something surrounding the termination clauses. And just one of the things that a lot of employers in BC don't realize is, yes, there are minimum standards set out by employment standards, and for the most part, they're intended to guide the employment relationship. But if you don't specifically tell your employee that law is the one you abide by and those are the terms and conditions you follow, then strictly speaking, if you were to end up in a court, you can't necessarily guarantee them. And that's where Sophia was mentioning the term common law. So common law basically steps in, and it's basically court precedent. And so when common law steps in based on all those court precedents, the reason for that is because it's the absence of an actual accurate and complete contract or offer letter that specifies otherwise.
Excellent point. And again, the why. Why do this? It's because it's so important to business.
Yeah, and I'll tell you, in my experience, just a last quick thing here. In my experience, people who have high turnover in their businesses in the first year after hiring, there's one of three reasons, right? The obvious, we don't do a very good job orienting and integrating them. The second one is bad managers. But the third reason, and the one that often as consultants we get called in to deal with, is that the explanation or the expectations or the promises made in the hiring process are not met. And you can avoid that loss by putting it properly down in an offer letter.
Definitely. Excellent. Thank you so much. That's a terrific overview, and I would invite Sophia to add anything or include an experience that you've had in this area.
Yes, I think Shawnee covered really all of the different sort of contract checklists that I typically advise clients to put in there. Maybe a couple of add-ons. The first one is if you have a probationary period, you could put that into the contract as well. And, as employers, giving yourself a little bit of wiggle room in the contract as well. So potentially, under the compensation and benefit section, having a little bit of a write-up in there saying that you have the right to alter the carrier of benefits as well. And a lot of companies go through potentially a different benefits carrier every couple of years. And so just making sure that you have that in the contract is important. And one hiccup that tends to happen quite often that I see with clients is that first off, they may not even have a contract in the first place, or the second part of it is they may have sent out an offer, but they don't have that acceptance piece. So the new employee hasn't signed off on that contract, and then they come to work and they start their new job and there's no signed contract. And so really at that point, that relationship and agreement between employee and employer is non-existent because you don't have that final sign-off from the employee. So my advice to clients is make sure that you send out that offer, but also make sure that it's been accepted before your employee has stepped foot in the door.
The finishing details, right?
Mm-hmm. Absolutely.
Yeah. Excellent. Really, again, excellent points. I mean, these are the learning steps, particularly for those women in business who are just at the stage where they're thinking about hiring someone. You know, this advice is just golden. Thank you. And then the third section that we want to touch on is obligations to employees. The employer's obligations to employees, both according to Canada Revenue Agency, but other areas. And I would invite either or both of you to kind of jump in here in this third section about obligations to employees.
Sure. So maybe the Canada Revenue Agency, that document I was talking about a little bit earlier for that distinction between employee or self-employed, it's called RC 4110. And so that's a really good document that is pretty comprehensive. It outlines the different tests that we talk about, and it also has a section there on more information and resources and phone numbers that you can contact as well if you have any questions. And really, ultimately, if you have an employee, employer obligations include statutory obligations. So they're legally obligated to deduct, contribute, and remit payroll deductions on behalf of their employees. So that includes WCB, employment insurance, CPP, income tax, and deduction of taxes. So that's one area, and an employer also needs to act in compliance with the Employment Standards Act within each province. So this includes things like vacation pay, protected leaves, overtime, stat holidays, minimum wages, and really the Employment Standards Act within each province. I have clients that operate within multiple provinces, and so you need to be careful with the nuances between each province. But each of these acts very clearly lays out the minimum standards, as Shawnee talked about a little bit earlier. So those are some of the obligations for an employer towards an employee.
Yeah,
excellent. And you're mentioning the OC 4110, so I think that ladies, participants on the phone, you will get a follow-up and we'll include that information on there. Yeah, excellent.
Can I jump in on any?
Yes, please do. Shawnee.
I think Sophia said it elegantly, making sure that the nuances across the different provinces are met, and that can be sometimes surprising to employers that, hey, what you do in Alberta isn't the same here, and vice versa. But and just in general, we do have an obligation as employers to behave legally and I would like to think ethically. At least that's sort of clients who call HR consultants at least usually want to behave ethically. And so when I think about legally, there's a few other things like in alignment with the minimum standards. Certainly, you do have to pay twice a month here in BC. We do have an obligation to provide a safe and secure work environment, and that includes mitigating the risks that exist. Not every environment is perfectly sterile and safe, but at the very least, if there are any safety hazards or risks, we're supposed to make sure that we train our employees to be prepared for them. And in the hospitality industry, that could be dealing with drunk people, and in the manufacturing industry, that could be dealing with the possibility of losing a hand or having a forklift run you over. So the obligations run the full gamut. When I talk about policies for employees, I always say to my employers, let's make sure that you have your bullying and harassment policy. My employers in BC, I should say. Bullying and harassment policy, your privacy policy, and your health and safety policies are really key, and make sure that those are in accordance with the laws and with the specific context of your organization.
Excellent points. Excellent points. And some that, again, small businesses, we don't think about, you have 3 employees and you're running a small cafe and, but a bullying and harassment policy, the absence of it, as you've explained, that, without a policy in place, where do you draw the line? How do you help new employees to determine what is appropriate and what is not?
Yes, exactly. And it is actually the law in BC that we are supposed to have a policy relating to that. So that's something that often comes as a surprise to my clients as well.
Mhm. Mhm. Is there anything else either of you, Sophia or Shawnee, either of you would like to add, just in terms of that, the obligations to employees? Have we missed anything?
Dawn, this is Shawnee again. If we haven't missed anything, is there also an opportunity to talk, Sophia and I, to share when you'd look to hiring an employee versus a contractor, or look to hire a contractor?
Absolutely. We've got another 7 minutes before we move into the question and answer, so that's an important piece, and absolutely, please do jump in.
Okay, because especially when you're in a startup or early stage portion of your business, it can feel like a lot to go and to, hire an employee. And most of my employers, when they think about hiring an employee, they don't just think about it like a monthly kind of thing, right? They're actually making a big investment. It could be a 5-year person, and so that $40,000 a year person is actually a $200,000 investment, right? So that can be a bit scary up front. So they think, okay, well, maybe a contractor would be a better approach. And certainly, I have had situations where the nature of the work is so short term, or they're not even sure that they'll have that client in a month. So it does make more sense to make an arrangement as a contractor type situation. And so, I just want to think, sort of think through some of those examples. I think, one of the core things that I spend or advise my clients on is that if the control is important to you, whether it's control over the output, control over the quality of what you're providing, or also control over the copyright, the actual information, then chances are an employee would be a better approach. And of course, if for some reason, it's truly, a position, let's say that there's a specialist, there's only one specialist in North America, and they aren't interested in being your employee, then if you are hiring them as a contractor, make sure that you do get your clarification on confidentiality, intellectual property, and copyright well documented in advance of signing and starting with that person, because the rules around and again, I'm not a lawyer, but the rules around copyright and intellectual property are different for employees and contractors. Employees in law owe you a duty of loyalty, and yes, we should still specify and explain to them that they're supposed to be loyal, and this is what loyalty means in my organization. And by the way, a handbook's a great place to do that. But when it comes to law, contractors and the work, the output from a contractor is actually it's seen and reviewed differently. The copyright rules even can be different. If you aren't clear on those kinds of things, you might want to do a bit of background check before you make the decision to hire one or the other. And that's to me the big sort of, if it's really short-term work, if it's, to fill a quick skill gap, if you're looking for somebody who, really they only work as a contractor, then take care of the agreement, the business agreement that you set up with them to protect yourself. On the other hand, you can have a fairly short-term person who is going to be under your command and control and direction that would, probably be better suited to be an employee. And the last thing I'll mention on that is you also have to look at the person you're hiring, because some people are really not prepared to be contractors. And that, you sort of be thoughtful about that process about, does it make more sense to hire them as an employee because this person really isn't equipped to do invoicing to me on a monthly basis. They need to get paid biweekly, and they're probably not in a position to know how to save for source deductions for their contributions. So maybe I better take that role on for them. And I think, again, as Sophia mentioned earlier, the risk as an employer is on you. You're the one who's going to be deemed responsible for this relationship. So you might as well make that decision with sort of, considering all the stakeholders.
Very, very good points. Very good things to consider.
And if I could add something, Dawn, on, I think quite a few clients have had the question of, listen, I've got an employee and I want to convert them now over to a contractor.
That's
how do
a
I do that?
common question.
Yeah,
That's
and how do I do that,
yes.
right?
Yeah.
And so, it's important here to note that when you, and let's say now you realize that this person is going to be a contractor, you've done that 4-point test and they meet all of those requirements to be a contractor. What you need to do at that point is your their employment will need to be essentially terminated from the company, whether that's resignation or whatever. But it's basically they need to be issued a record of employment, along with their final pay, vacation earnings, any statutory obligations. Benefits are going to cease as well on their last day. Current vacation earnings need to be paid out. Essentially, it's kind of cleaning the books, going, okay, we're ending that relationship between an employee and employer. And then the next step is then drafting a contractor agreement. And so then it shows the commencement of that new type of relationship that outlines what their role is as a contractor and just what the services look like and invoicing and so forth. And so it's important to note here that any type of changes to an employee-employer or an employer relationship, the contracts always need to be updated. So whether that's an employee's role is changing, whether it's their maybe compensation that's changing, the contract accordingly needs to be updated as well, so you have the most up-to-date representation of what that relationship looks like.
And that would apply so much to many of the women in British Columbia and small businesses are changing from full time to part time. They're
right.
Verbally suggesting to an employee, well, you know what, things are a little bit slow right now. I'm going to put you back on part time.
Right.
But the suggestion to be sure to document those things is crucial.
Absolutely. I mean, oftentimes you may hire somebody on a fixed term contract, right? Temporary, as Shawnee had mentioned. Maybe at that time in the business, it made sense to hire somebody on that fixed term type contract with a definitive end date. But maybe this person's just the right fit for the business and you do want to extend that offer or you do want to then hire them full time. You need to then update that contract. It needs to be a new contract stating that now they're being hired as a full-time employee. And again, you need to have that acceptance component done as well with the sign-off. And then that way you just have everything covered and you have it documented with that new relationship between you and the employee.
Mm-hmm. Yeah, and if I may, take heart, ladies and gentlemen on the line, because we worked with lots of big companies and they forget to do that too. So
yes.
If you get that, if you get that in place, you're doing better than a lot of organizations. And of course, frankly, that's probably, I don't want to speak on your behalf, Sophia, but that's why my business exists, and I suspect you too as a consultant. We do this stuff for you, so you don't have to labor online. We're kind of your Insta HR Google.
Absolutely.
Yeah, excellent. My goodness. Well, there's so much information and there's so many takeaways that both of you have offered. To our participants on the line, we have Sophia Oriche from the principal of Upskill Consulting in Langley, and we have Shawnee Love of Love HR in Kelowna. You've got some expertise right here at your fingertips, and if you have a question, you can take your phone off mute, as long as you don't have a lot of background noise, and ask your question. We've got some time set aside for these questions. Sophia and Shawnee, I'll just invite you to, whichever of you feels ready to jump in and answer the question. So ladies, if you do have and gentlemen, there may be some gentlemen on the line, if you do have a question for the experts today, please do. Go ahead and ask your questions.
I have a question. My name is Virginie. My question is concerning family members. If you're going to hire family members or if it's a family business, I would think that these same rules apply. But do you have any tips or recommendations, that deal specifically with family members?
Yeah, I can jump in on that if you want.
Thank you.
So you're absolutely right. The same rules apply. Get it in writing, document it. In some cases, have those conversations not only with the employee about their specific terms, but with all of the employees in general about, this is a family member, but here's how, we expect them to interact. Most small businesses, when a family member comes in, there's a little bit of nervousness because, what does this mean? Are they going to shirk and not work hard, or are they going to, stand up and be the hardest working person in here? So it's good to have those kinds of conversations up front. Beyond the obvious, you have an individual who hopefully, as a small business, you are able to review their work and or have somebody supervising them that gives them a little bit of arm's length distance, so it doesn't feel like there could be favoritism, but also so that you're not necessarily super, super hard on that individual. And, candidly, the security of family members is chances are they're not going to sue you, right? At least that's what we hope. So if you make a mistake and you have to, shorten their hours or increase their hours, chances are with family members you get a little bit of flexibility there, which is one of the reasons a lot of my employers like hiring them. They know that they're going to fit the culture. They know how they work already. They know that if they don't toe the line, they can have a conversation over Sunday dinner and everything will be back on track. And so there's a lot of confidence and security in that type of person. On the other hand, where I see hiring family members goes awry is if they, either sort of seem entitled and don't necessarily step up to the level you'd expect them to, or if you place them into a position that other employees believe they were on track for and suddenly have a lost opportunity, or if there's truly obvious favoritism.
Yeah, and I say depending on the size of the company as well. Oftentimes I'd suggest to clients just to avoid sort of that nepotism aspect is, if possible, have that family member report into somebody that is not a family member. So you have a little bit of that kind of impartial maybe feedback and promotions and that kind of thing that Shawnee was just talking about. So those reporting lines can come into play as well when it comes to hiring family members, and to avoid any of that sort of the feeling of nepotism and maybe favoritism in the company.
Great.
I have another
Thank you for your question.
Here.
And there's another question. And can we?
Yeah.
Is this the same person? Can we let someone else on the line?
No, this is Linda here.
Okay, thank you. Go ahead.
I have a question. I have a retail store, so I have one or two employees. Does this mean that I have to have a contract for each employee I hire?
My suggestion to you is yes, having a separate contract for each of those individuals. And as Shawnee mentioned earlier, it doesn't have to be an incredibly robust 6-page contract, but as long as it contains, basically start date, their term, like whether they're fixed term or kind of part-time or full-time employee, probationary period, their position and duties, and compensation. That's a good starter for sure. But I would say any employee that you hire, we shouldn't rely solely on an oral or verbal contract. Having something written is a tangible that, just in case anything comes back, any questions that may come back, you have something tangible that you can offer going, listen, this is a contract that they've signed off on, and this is our relationship. This is when they commenced work, and here's their pay, and this is when it was signed off. So I say just to kind of cover your tail a little bit, having that written contract is important.
Okay, but it's not mandatory, is it?
No,
No.
I'll just build on what Sophia said. It's not mandatory, and I want to caution, it's when you have an offer letter put out before somebody starts working for you, and then as Sophia said, you get it signed before they start working, and then you have that formal agreement. That's the ideal, perfect how it's supposed to work. But if you don't already have an offer out and you have those employees working with you already, there's a little bit of a process to go through in order to provide somebody with an employment offer. If you want it to actually be worthy of what your effort is being put in. And what I mean by that is like any kind of contract in business, you kind of have an offer and an exchange. But if you give somebody an offer when they're already working with you, they're not really getting anything in return for signing it. And so that usually isn't going to be very effective. So, in legal terms, you would want to give them some form of consideration, and chances are you'd want to give them some form of notice. Just practically speaking, if you've got somebody, in your retail stores you described where, they've been happily, merrily working along and you haven't had any issues, and now you hear us coming along and saying, hey, you should really have an offer letter. At this point, I might suggest having, rather than writing a big offer letter or anything, just sit down and write a confirmation of employment that outlines, hey, over the last year, these are the things that we've been doing. We've been paying you this kind of wage, and we've been giving you this kind of vacation. It doesn't mean that it's a formal agreement that would stand up. But what it means is that you're just making sure that, hey, is this what you think we're doing? Because this is what I think we're doing. And then if you promote the person, let's say to key holder, then prior to giving that promotion, you'd be in a position to write that offer letter that says, hey, by the way, for this new promotion, here's your new job and here's your new rate of pay, and it's going to take effect on this date. And by the way, you've worked with me for 2 years, so there's no probationary period that applies. And here's your benefits, and you can formally do that at that place and actually make it a valid agreement between the two of you.
Okay, I'm just wondering if it's something new. I've never had to sign a contract when I've worked.
Yeah, I mean, in fairness, if you've never had to sign a contract, what that means, and Sophia already mentioned the term common law would apply, and so the big reason for employers to worry about common law applying is because under employment standards, as an example, the maximum, if you have a formal agreement that says we follow employment standards termination laws and rules, then if somebody's worked with you for 20 years and you decide, hey, I can't have them anymore, under employment standards you only have to give them 8 weeks notice or pay in lieu of notice. Under common law, it could be 20 months. So you really, it's really a factor, and I'm using that as one example. There's other examples where common law would be more generous than the Employment Standards Act.
It usually is, in my experience.
Yeah, of course, you're right. Yeah.
Yeah.
So if it never comes up for you, that's wonderful. Clearly you're doing some things right. And really, I always see my role as one of risk mitigation and informed consent. So I want to make sure my employers know what the risks are and they're making those decisions consciously. An offer letter is one protection that can be really successful for employers. Certainly covered a lot of butts in my now almost 30 years of experience. But if you don't have one and you're really happy without it, there's no offer police, that's for sure.
Okay.
I have another question.
We've got time for one more question from
Hi, this
someone.
is Lynn.
Lynn, hi Lynn, go ahead.
Hi, I'm in a special situation. I'm the executive director for a nonprofit organization that was provided a lot of the templated contract agreements at the beginning from actually ministry. And we used those and came to the realization that, in fact, we didn't have contractor, we had employees, just as you mentioned the test by CRA. So we actually, rather than renew our contractor's agreement, we're in the process of moving to employee status. What I'm hearing from you based on the last question is that I should essentially now sit down and write a letter of confirmation. What has the process been up to now? And then go ahead and draft an employee contract based on the content you said. Is that correct? Am I hearing you right?
So I would personally way prefer to have that conversation specific to you because there's a few more details that I should probably check before I can truly advise. But there's absolutely good value in writing formal offer letters if you are officially, confirming that somebody's an employee, but there's a lot more detail that goes into that. So
yeah, Lynn, it's a great question. It's a great question, but as Shawnee is explaining, I think it might be a little too detailed for our session for today.
Okay, and are we going to get your contacts in the email that comes back?
Yes. I'll just confirm that now as well. So to all our participants, you will get Love HR and Upskill Consulting, both Shawnee and Sophia's contact information in a follow-up email following today's session. Just as we're getting ready to close off, I would like especially to thank our two experts. This has just been a terrific mentor advisory forum on a really important topic. I wish we had more time for questions. There's lots of information that our two experts hold, and I'm glad that you had this opportunity. It's completely up to you if you want to connect with them after the session. You will get their contact information. But again, as volunteers, we could not do this without people like Sophia and Shawnee. We could not hold these mentor advisory forums. So on behalf of Women's Enterprise Center, I would like to thank you both so very much. To our participants, I would also ask you will receive an evaluation as well. We'd love to hear what you thought of the session. If you'll take a minute, it's really helpful. Again, my name is Dawn. I'm a business advisor with Women's Enterprise Center. Shawnee and Sophia, I'll give you the very last 2 minutes between you. So jump in.
I'd just like to take this opportunity to thank everybody. This has been a lot of fun. Shawnee, it's great to tag team with you as well today on this. And, I think we can tell with all the questions coming in as well, it is a hot topic. And so, my pleasure today being here and looking forward to connecting with many of you. If you have any follow-up questions, more than happy to help you out with any of those. So thank you.
Yeah, and just the same here. Really enjoyed this opportunity. It's a first for me participating in a teleconference this way, so it was really fun, and I'm so excited that it was a really hot topic. And from my perspective, one of the things I do, and by the way, happy to hear calls and questions, same as Sophia. But one of the things I do is I have a blog where I blog weekly on different topics of interest, and certainly employee versus contractor has been a blog topic in my repertoire for the last 10 years, I guess. And actually, in honor of this, I just put out a blog this morning as well. So you'll be able to get some more information at wec.ca if you're interested, or give us a call. Thanks.
Wonderful. Thank you both, and thank you. We couldn't do it without our participants as well. So thank you for being a great and engaged audience, and some great questions there. Please do take the time to review the information being sent to you after today's session, and take a moment or two to fill out the evaluation. It's great. It's great feedback for us at Women's Enterprise Center. Thank you, everyone. The copy of the recording will be on our website.
Yeah, and thank you very much for giving us this opportunity.
Thank you. Thank you for your thank you. Much appreciated. Bye now.
Bye.
Bye.
300.